Relocation is the name given to cases involving the request by one parent to move out of state with a minor child. It's governed by NRS 125C.200. A parent wishing to move must request the written consent of the non-custodial parent. If the non-custodial parent refuses that consent, the custodial parent must petition the court for permission to move the child before the move. In 1991, in the Schwartz case, the Nevada Supreme Court held that in deciding whether or not to grant permission to move, the district courts of Nevada are supposed to balance three ways: the interest of the custodial parent's freedom of movement against the best interests of the child, and against the competing interest of the non-custodial parent, a multi-part test. The party seeking to move must demonstrate that there is an actual advantage that will be realized by both the child and the custodial parent if the move is granted. If the threshold requirement is met, the court must then examine the following: A, the extent to which the move is likely to improve the quality of life for both the child and the custodial parent. B, whether the custodial parent's motives are honorable and not designed to frustrate or defeat the visitation rights of the non-custodial parent. C, whether the custodial parent is willing to comply with any substitute visitation ordered by the court in the event that permission to move is granted. D, whether the non-custodial parent's motives in opposing the move are honorable. And E, whether if the move is allowed, there will be a realistic opportunity for the non-custodial parent to maintain a visitation schedule that will adequately foster and preserve the parental relationship. Now, if the answer to that last question is no, if the move is so far, say to the other side of the planet, that regular visitation cannot be maintained, the move might be granted anyway, if the reasons for the move are honorable and in the best interest of the child. But the standard changes somewhat, since the choice to be made really is one of near sole physical custody. There have been at least a dozen relocation cases issued by the Nevada Supreme Court since Schwartz, the summaries of which can be reviewed on this page of our website. Additionally, in 1999, the Nevada legislature amended the statute to delete references to a parent having joint custody and inserted a best interest test into the move statute. The impact of the statutory change on the existing body of case law is not completely certain. At root, however, every relocation case involves comparing what the child's life would be like in each location if the relocation is granted, on the one hand, and if it's denied, on the other hand. So both parents have the burden of proving, as closely as they can, what daily life, school, home environment, and contact with the other parent would be like in both sets of circumstances. It is a factual matter, and these are very difficult cases.